So, Peter, we are so lucky to have you as the director of our sports law track here in our Entertainment Arts and Sports Law LLM. And just want to go through some of the courses and some of the content that you are teaching in each of your one-credit short courses in the spring semester in Miami, which are open to both LLM students, joint degree students, as well as JD students, and quite popular among the JD students. So we start with representing the pre-professional athletes. So you want to kind of take us through that course?
Sure. So we talk about NCAA compliance. We talk about some of the scandals, unfortunately, that have been visited upon certain of the programs here at Miami back in the day, which is now entirely cleaned up. But we talk about University of North Carolina and the academic fraud scandal. We talk about, you know, what is required to keep your amateur status as a student athlete. We don't talk about it. We teach what the rules are for agents who want to go prospecting, what they can and cannot do, what the agent's rules are, what the student athlete's rules are to maintain student amateur eligibility. We look at all those things again, in a very serious sort of legal lens rather than just a sports center way. Right. You know, because again, it's strict contract interpretation, very serious rules and regulations interpretation, and big compliance department and job opportunities. It is a big job opportunity because it's a growing area.
Then we move into another one-credit course on representing the professional athletes. So then they've now turned pro. And what issues do you encounter in this course?
So now we go pro. We talk about the representation agreement. The agent is now allowed to recruit the student athlete. We're past the amateurism. We're past the O'Bannon. We're past all the pay-to-play issues that we look at on the pre-pro course. And then now he or she has decided to turn pro. How does he or she negotiate and draft a contract to be represented by an agency? We go into the first product endorsement agreement. I'm a golfer, I'm a tennis player. What club do I play? What racket do I swing? And how do I get paid for that? What kind of an agreement do we negotiate and draft? So this is hands-on clinical sort of, you're actually the lawyer for a client and you're negotiating and drafting a product endorsement agreement. And then we go to a license agreement, which is a publicity rights, right name, image, likeness rights. Poster. Are you allowed to use that in a product I don't use on the course, but I am involved in that product, and First Amendment right to transform it to fit the artist's rendering, or is it really a knockoff and I should cease and desist that. So we look at a lot of these things, and we look at the 4 stages of professional athlete's career. We look at the concussion litigation, and we look at what happens when the cheering stops, post-retirement opportunities.
And then we look at the third course now, which is negotiating and drafting sports venue agreements.
Right.
You get a lot of different agreements related to the venue, so do you want to kind of take us through that course?
Sure, Greg. Well, now you're representing the owner of Hard Rock Stadium or Marlins Park, and now you're doing a lease agreement. You're doing a naming rights agreement. You're doing a presenting sponsorship agreement, an official credit card of the Dolphins or the Marlins or whatever it might be. And then you're doing food and bev, which is really important. It's what makes the sports world go around. You're doing a beer deal. You're doing a pizza deal. You're doing media rights deals. So all the things that the owner of a sports venue, the owner of a sports team would need to have negotiated and drafted, and we play act that. It's clinical. It's hands-on. We go around. We do selective clauses from each of those agreements, hospital medical service provider agreements, and we play act, but not so much. It's the real world. You're taking on the role of counsel to the owner of a team. Well, what should my media rights agreement look like? You know, what should my financial services agreement look like?
And then the fourth course, which we just recently added to our curriculum, is the only of the 4 courses that you teach that is exclusively to LLM and JD LLM Entertainment Arts and Sports Law students. And this is a requirement as part of the negotiating and drafting requirement of the sports track. Purchase and sale of a minor league baseball team, something in your career you've done.
A lot of, yes.
So you're drawing on your actual experience, and can you take us through kind of that course and how the students?
Sure. Well, it's a chapter in the book, so I have books that go along with each of these courses that we're talking about, and just the second edition, West Academic, Negotiating and Drafting Sports Venue Agreements, we have a new chapter called Purchase and Sale Agreements. So this is very complex commercial. You might think, oh, it's minor league, but every clause counts. Every negotiation counts. We're buying and selling, you know, these are multi-million-dollar properties, not billion-dollar properties. So we're negotiating a very sophisticated commercial transaction, and we're delivering what they negotiate, the LLM students negotiate, and draft, and I'm supervising, would be ready for a closing on the sale of a minor league team. You know, we assume something in the area of $5 to $10 million, maybe more, and we do each and every clause, as opposed to the other course, each and every clause, and we deliver an agreement that's ready to be signed to close the deal.
And something that you've hit on in each of the descriptions that I want to reemphasize, because I've sat in on your classes, is the clinical nature of these classes. The students are role-playing, they're taking sides, they're negotiating, they're drafting, they're putting in these clauses based on these negotiations.
Absolutely.
Can you talk a little bit about that component that is overarching in all of your courses?
Yeah. Yeah, so welcome to my law department. Well, you know, I was general counsel at IMG. Welcome to my legal department that does sports law when I was a partner at Jones Day. So I'm the senior partner in the firm, or I'm running the legal department. You know, and I've given you these assignments. I am going to supervise you. I'm not going to put you out to sea. I'm going to give you templates. You can cut and paste and mix and match. I have all sorts of sample agreements, but they're not quite right for the right reasons. So we're really tweaking these agreements. Every word counts. And it's a laboratory experiment. Can you deliver back to me something that I call it's execution ready? You're ready to hand to a client and say, sign this, I'm comfortable, you're covered.
And I just think the students love these courses. I know you love teaching the courses, and we couldn't be more happy to have you here as part of this program, you know, teaching and educating the next generation of sports lawyers.
It's a great privilege. I'm proud to be here, honored to be with you and Dean White, and you know, I think we've built a very firm foundation. I think anyone who's interested in pursuing this, it's a unique opportunity, and there's really no competition out there for what we're able to offer here.
Well, thank you, Peter.